to start off by obviously pointing out that on a creedal matter, we would have seen this in the news very recently, and this is a criminal liability aspect of it. This is where, for example, people were able to identify boy A and boy B, and they're being prosecuted for that. And it just shows how quickly information can be disseminated over the internet and social media platforms. I'm going to concentrate on the civil liability side of this. And I'm going to talk about intellectual property infringement in particular, and then defamation. If we look at what happens online and how IP infringements can take place, obviously you can have online marketplaces that have sale of counterfeit goods. You can have copyright and design infringements that take place. You can have impersonation of counterfeits, impersonation of companies to try and missell various things, so rogue websites and the like. And also you can have the sharing of content, such as music files, illegally for free between users. And all of these issues can come to sort of IP infringements. And then the question is, to what extent are online service providers liable for that, even though it is ultimately an individual behind it that might be anonymous or not? But looking at the legislative framework and how sort of defences have come about for online internet service providers, the e-commerce directive from 2000 at this stage is 20 years old. And this is still the bailiwick of what the defences we would look at in the context of online liability for companies where they have complaints made against them. Probably has been exposed a little bit now that it's, you know, the internet's come on so much in 20 years. How people interact with the internet and social media has probably shown some weaknesses in this to a degree. And we've seen, and we will talk about how legislative developments have come about to try and improve that. But there are three main defences. The one is the mere conduit defence under Article 12, and that deals with the broadband provider, the one who provides the pipes for the transmissions to take place, has no interaction whatsoever with the content or modifies it in any way, is simply facilitating access to the internet, and to what extent liability would arise for them when there are infringements taking place. There's caching, which would be obviously the storage temporarily on a computer or a server and the like to facilitate certain acts, such as an internet transmission of a messaging service or something like that, like WhatsApp or something. Hosting is probably the one we see the most. And this is where websites or social media platforms are facilitating user-generated content, be it the likes of YouTube, where people are putting up videos, or indeed Facebook or Twitter, where indeed they're putting in, expressing themselves by way of sort of commenting and the like. But it obviously will apply across the board to various websites, blogs, some media websites that might facilitate customer or user commentary. This legislative framework provides that in any of those instances, there will not be liability for what is going on the network or on the hosted site if there's no knowledge of it. For the hosting defence in particular, if you were notified of it and it's unlawful, you need to act expeditiously to remove it, or you may be held liable. So that's the principal test that we've seen at the moment. But again, when the legislature was looking at this over 20 years ago, it was very clear that it wanted to ensure that these companies could foster and grow in that age, and that therefore there would be no general obligation to monitor on networks. So member states can't impose that obligation. So that's either the legislature at a national level, or indeed the courts as an emanation of the state cannot ensure that service providers need to see what's on their network and to hunt down sort of illegal activity and the like. Having said that, the Commission is very conscious that, again, in 2017 had issued a paper that there needs to be some level of good Samaritan for platforms in the sense of hunting down the most egregious, perhaps, content, such as child sex abuse content or terrorism type content. And so therefore there should be the ability to use automated tools to ensure that certain things remain off platforms and off networks. And the Commission has published this paper to indicate that that type of Good Samaritan Act shouldn't interfere with the defences under the e-commerce directive. So that's quite important. Again, and we'll see this in other cases, there's an ability to allow automated type processes. It's when it becomes more manual that the defences potentially slip away. And we'll look at a few cases that might have looked at that. One of the big questions is, well, what is notice to sort of notify a website that there's something wrong with their network in the sense that there's IP infringements on it or defamation, as we'll talk about in a moment. And the L'Oreal case had to do with the eBay marketplace. I think we're all familiar with that. And the question is to what extent eBay was liable for the sale of counterfeit goods. Now, it was held that if it's just putting up customer ads for goods, it can't be held liable. Same with Amazon. And even more recently, there was an Amazon case to say that even though Amazon might store the actual goods in a warehouse, if they've no interaction with the ads on the website or aren't promoting them, they're not liable. But this case was before that and equally was holding that as long as there's no promotion of the goods as such by eBay, but everything's more automated and passive, there won't be any liability. But what's important here is that the Court of Justice recognized that you can get notifications which are not substantial enough to actually be able to tell whether something is unlawful or not. And at that moment, you're not really put on notice as far as losing the defences are concerned. The standard which the Court of Justice talked about was that of a diligent economic operator. So that's the standard test that a court will look at as to whether the notification was sufficient or not. Just looking at some of the cases that we've seen, so broadband providers and the like, what we know from the Scarlett decision is that based on a balancing of rights, you cannot oblige a broadband provider or indeed a hosting provider in a subsequent case to monitor content at a general level. In other words, everything that's going up or going through the network can't be sort of monitored to check it, because that is interfering with, on the one hand, there's the rights holders' rights to IP under the EU Charter, but there's also the ISP's rights to conduct its business in a fair manner and a reasonable manner, which is weighed in there. Having said that, the UPC case from Austria shows that there can be, for instance, website blocking orders made against ISPs, and that has happened a number of times in Ireland. Started off with the sound recording companies getting orders against the likes of the Pirate Bay website, which are blocked on a number of broadband provider networks here in Ireland. But then it moved on by way of a more dynamic relief. The Premier League and UEFA in more recent years have got orders which require the broadband providers to effectively get notifications in real time. So somebody might be streaming the Premier League game in unauthorized manner and get blocked, and there's a bit of a whack-a-mole that goes on, and they put it up somewhere else in another server. And again, what happens here under this order is that the ISP takes in the notifications during the match and has to sort of play that whack-a-mole and shut down the streaming. But as I said, there is this balancing of rights, and that's important. And one of the bigger cases in this jurisdiction, certainly, was the Sony Music and UPC case. UPC are now Virgin Media. And this sought to make Virgin Media, which we call them now, liable for the access of subscribers around file sharing of music for free. And what was sought was some sort of 3 strikes and you're out type thing, where the rights holders would notify Virgin Media that a certain subscriber that they couldn't identify because it was only an IP address on the internet was infringing their copyright, and that they needed to be written to. And then on the 3rd such letter, they'd effectively be suspended or taken off their broadband subscription. There is EU legislation which pretty much enshrines internet access as a human right, and it indicates that there has to be a guarantee that there must be a prior, fair and impartial procedure before anyone's access to the internet is sort of cut off or questioned. And this procedure didn't exist in this structure. And for that reason, this 3 strikes and you're out wasn't what the court could order here, and the Court of Appeal conceded that. But more so, it was 3 strikes, and then there was a small list that would fall under this Norwich Pharmacal type relief, which Eimear will talk about in a moment. But what's also important about this from the context of companies that are providing services, be they broadband services or indeed the hosting side of it when solutions are looked for, is this cost sharing element. And the majority of the costs in this case were held to be borne by Virgin Media on the basis that they made money from subscribers. Now, interestingly, the UK Supreme Court in the Cartier decision has more recently looked at this EU legislation and held that it shouldn't be the service provider that actually pays those costs. It should actually be the rights holder who's benefiting from the measures that are put in place. And if they need to go after the infringers ultimately for cost contribution, then that can be the case. So it's quite interesting to see this decision here in Ireland, a completely opposite decision in the UK Supreme Court, And if this gets revisited, it'll be interesting to see to what extent there may be rebalancing of who is expected to pay for who. Perhaps along the lines of what the UK Supreme Court was saying, in that in Norwich Pharmacal type cases, which Eimear will talk about, when you're an innocent intermediary asked to disclose the identity of a wrongdoer, you're in no way culpable and you shouldn't have to pay the costs of that, and in fact have your costs reimbursed for complying with that order. But Eimear will talk about that momentarily. One recent case where hosting platforms, in this case, it was a case taken by Allianz, the insurance company, against Tesla, which was this company which was claiming to be insured to the tune of $1 billion and had put up forged insurance certificates with the Allianz trademark on it. So obviously, Allianz wanted to stop this advertising from Tesla, but the various social media platforms in which the advertising was taking place, in this case, Google were operating YouTube, Facebook, and Pinterest. They were joined to these proceedings. Now, it turned out that maneuvers were made and a settlement was made as to regarding the content. So ultimately, an order wasn't granted against the social media companies. They were only granted against Tesla to cease its activity. But effectively, this is a good example of where it's possible to go into the High Court, and Ms. Justice Reynolds in this case, and seek orders around content that's there. Obviously, the Article 14 defence would run to the extent of liability around damages. But again, all of these defences don't necessarily prevent a court granting an order. It's just that the liability side of it, be it damages or costs, you should fall within hopefully the exceptions here, as long as you're not on sufficient notice and have failed to act. As I mentioned, the e-commerce directive is a little out of date. So certainly in the copyright space, and I've talked about a number of cases where sound recording companies have tried to do things to assist stopping of dissemination of copyright material, in this particular case, sound recordings. We have an EU copyright directive that's going to be amended now. And we'll talk about other legislative changes, but I think it's clear that as the internet has developed and how people interact on it and how people are so reliant on it, there needs to be a sort of changing of the guard in the sense of the type of wrongs that can be pursued and how these defences have to be nuanced. And this is an example in the copyright space. This new directive provides that instead of the Article 14 hosting defence for copyright works that users put up on platforms such as YouTube, there is an obligation, or there will be when this comes into law in 2021, on those providers to try and get licensing arrangements in place to ensure that if that type of content goes up, that there is a sufficient remuneration flowing to the rights holders, even though they may be done in an authorized manner by the users. So now looking at defamation, we have our Defamation Act 2009, which is quite clear in providing that online defamation is certainly something which is actionable under our Act. And we see a lot of complaints for online defamation. And as I said, it's the new way of sort of defaming somebody. And it's probably to a degree quite attractive. And this is the reason why we're going to talk about Norwich Pharmacal Relief, in the sense that people can do it in a relatively anonymous way. And that has led to the requirement to try and identify wrongdoers to pursue them. But at the same time, has meant that providers that facilitate users posting commentary and the like and expressing themselves have found themselves intertwined or entangled in these type of disputes. What's important here to note from an internet publication perspective, and I'll talk about some more nuances about the fact that it's really widely disseminated, but the date of first publication is the most important date from a statute of limitations perspective. And we often see complaints where content has been online for quite some time and the complaint is only raised. If it's there for a year, then it's going to be statute barred. And we've seen content that's a year old, and some of it's not a year old, but it's the same content, and there's a sort of an anomaly there as to you pursue the latter stuff, but not the sort of the former content. That year can be extended through a court application for a further year if the interests of justice require it. But what's also interesting about defamation proceedings here, and what the 2009 Act tried to do, is it requires with the pleading, such as the statement of claim, that the plaintiff puts in a verifying affidavit on oath that the claims that they are saying are defamatory are in fact defamatory. So they're swearing up to that fact, as opposed to simply pleading it in the pleadings in the case. So there's an extra burden. It's obviously not insurmountable by any stretch of the imagination, but it is definitely something which has tried to ensure that claims that are made for defamation are certainly followed up properly. There are defenses to defamation, and if you look at it from a service provider perspective, the difficulties are many of the defenses, such as proof and honest opinion, are really ones that the poster of the content can rely on, because they're in a better position to look at the veracity of a particular statement to see if it's true or false. They're obviously more familiar with the details that they're disclosing, as opposed to the service provider. The service provider that gets entwined in all of this finds themselves obviously relying on the technical legal defenses, such as the e-commerce defenses I mentioned, the Article 14 in particular, where somebody's posted defamatory content, you're claiming you don't know anything about it because you don't monitor and the like, but also the defense of innocent publication, which I'll talk about now. And that defense is strictly for defamation. Obviously, e-commerce applies to IP, defamation, any type of wrong that might take place on the internet. So from a defamation perspective, under Section 27 of our Act, there is a defense which provides that if you're not the author, editor, or publisher, and you've taken sort of reasonable care and haven't contributed to defamation, you should be able to rely on the innocent publication defense. And this has come about in the online context. First case that looked at the e-commerce defenses and the interaction with defamation is the Mulvaney and the Sporting Exchange Limited case, and that is to do with Betfair. What was interesting in this case is that Betfair ran a chat room, and on the chat room there were defamatory comments posted. And they tried to rely on the hosting defense. And one of the arguments contrary to that by the plaintiff was, well, betting services are actually exempt from the e-commerce directive completely, and therefore you can't rely on defenses contained in the e-commerce directive. Now, Mrs. Clark did in this case something which is actually being sort of also done in the UK, and adopted sort of a principle of severance in the sense that, well, yes, there's a betting aspect to the site, but there's also a chat room aspect, albeit maybe about betting, but it's a chat room aspect, and you can sever that and hold that aspect of the website can rely on that defense. And that's important for companies that are engaged on websites that they maintain the homepage or whatever the content may be, and they do facilitate customer or user commentary. In that case, whilst they are obviously more than hosting, they're actually interacting with content on the website, they can claim that they're hosting simply the content that's put up by users that they're not aware of and simply rely on these defenses. So it's a very useful precedent from that perspective, and indeed English cases have taken a very similar view. I'm going to look at a Eimear decision, which is probably one of our only decisions around online defamation that we've seen, certainly under the 2009 Act. And it's a decision which was granted a few years ago, which is Vinci, and it involved somebody called TBO who was anonymous, and I'll have Eimear talk about that aspect. But what was sought was effectively an order under Section 33 of the Defamation Act to prevent further publication on the Facebook platform. And the orders under Section 33 facilitates a court to grant the prohibition of further dissemination of the information if they feel it's defamatory or if the opinion is defamatory and there's no defense that's reasonably going to succeed. Now, sort of what's interesting about this is defamation cases in Ireland are heard by a jury. So even if there's online defamation cases and there's a poster being sued, but also platforms, the case will be heard by a jury because that's how our defamation cases are heard. What was attempted here was to get an order to bring it down sooner on an interlocutory basis. And what went against the granting of this order, which was sought by the particular individual, was a couple of things. The content was considered defamatory by the court. So the first part of that test was passed. However, the court did struggle with the fact that the content was on many websites, not just Facebook. So even to grant the order against Facebook would be futile to an extent because it wouldn't stop the dissemination or the fact that this information was indeed in the public domain. But it's the second aspect of the test which is important, and it's what I'm going to focus on now. And I'm going to go through two paragraphs in the decision. There's no need to sort of read them there. And effectively what they're saying is that First off, under Section 27, from Facebook's perspective in this case, they were merely providing facilities for users to post content. And therefore, they weren't within the sort of publisher realm that was seen in the test under Section 27. But secondly, an argument was made that, well, hold on a second, by the plaintiff, they've been notified of this content and they failed to take it down. So in other words, when I was speaking about Article 14 and the defence there is a requirement, if notified of unlawful content, to remove it expeditiously. Now, that does pose problems for platform providers who clearly don't monitor and clearly aren't in a position to establish whether something's defamatory or not. But interestingly, Mistresses Binchy in this case held that the test under innocent publication doesn't have such a notify and takedown requirement. It simply says if you pass the test of you're not a publisher, you've acted reasonably and haven't contributed, you can rely on it. And this is exactly what Mistresses Binchy held in the Moema decision. So it's a very interesting decision and useful decision when a company is accused of having defamatory content on its website. Finally, I'm just going to look at the extent of orders that can be granted in a defamation context. And this has come up again. Facebook found themselves the party to an Austrian case and a Court of Justice reference here. And effectively, it was confirmed that Facebook could rely on Article 14. I don't think that was necessarily something that was too contentious. But more so, the question of, yes, the content can be ordered to come down, but two aspects to it. Could it be ordered to be taken down on a worldwide basis, even though Facebook might be based in Ireland in this particular case? And the answer to that was yes, from the Court of Justice, as long as it was done in accordance with international law, there could be an order of that nature made by a national court. But secondly, what the plaintiff in this case wanted to achieve was an order that prevented further content, not just the content that might have been originally notified, being put up. And this caused a bit of a friction between Article 14 and 15 and obligations to monitor, and indeed the plaintiff's requirements to protect their good name going forward. So what the court held here is, yes, you can have an order which prevents identical or equivalent content going up if it's posted subsequently by the same or even a different user, but what the focus is on is the fact that the content has to be pretty much identical. In other words, the same words used. That's for two reasons. First of all, it facilitates the use of automated tools, which I mentioned seemingly is liked by the legislature, the commission and courts, etc. And certainly something that's encouraged. But also that the service provider does not make an assessment of whether something is defamatory or not. In other words, are the wording meaning the same thing as the post that was actually the subject of the proceedings? It's not fair to put a company in that position to make that type of assessment. And therefore, that's why there is this requirement that it must be pretty much identical content. So it's interesting to see, this is a relatively new decision, how orders will be framed in Irish courts now going forward on a defamation side of things. So I'm going to hand you now over to Eimear, who's going to talk about some legislative developments and then Norwich Pharmacal relief.
Thanks, Jerry. Good morning, everyone, and thanks again for joining our webinar this morning. So I'm going to focus on two legislative developments, or two bills that are currently in draft form, working their way through the Oireachtas. The bills that I've chosen to look at, they're not specific to the areas of intellectual property and defamation that Jerry touched upon. They're going to affect online liability more generally, and they involve criminal and civil aspects. So the first one I want to look at is the Harassment, Harmful Communications and Related Offences Bill 2017. And this bill was moved to the committee stage last month. And the proposals in this bill come from a report from the Law Reform Commission on Harmful Communications and Digital Safety. And the overall intention of this bill is to tackle online harassment and cyberbullying. So when we speak of harassment, those of you who are familiar with the offence at present will know that it's a criminal offence. It's found in Section 10 of the Non-Fatal Offences Against the Person Act 1997. And the first section that I've chosen to look at here, Section 3, is going to expand that offence to include intentional or reckless harassment. Section 4 of the bill is intended to introduce a new offence of distributing an intimate image without consent. And Section 5 will deal with prohibited messages, so sending threatening messages, but also sending false, indecent or obscene messages. So the second bill then is the Online Safety and Media Regulation Bill, which I've looked at in the next slide. This is in much earlier stages of its drafting. The general scheme was approved by the government only in January of this year, and a virtual workshop was held to discuss the contents of the bill in June, and it's now in the process of being drafted. So we really only have the general scheme to go on. But what we do know is that the main purpose of this bill will be to establish an online safety commissioner as part of a wider media commission. And the intention is that the Media Commission will replace what we now know as the Broadcasting Authority of Ireland. It will absorb the Broadcasting Authority functions, but it will also have an increase in functions, and it will regulate the audiovisual sector as a whole. And the establishment of the Online Safety Commissioner will be a significant change in this area, because internet service providers or relevant internet services that will be defined under the bill, they will be regulated by this commissioner. And what will they be regulating? Well, in essence, the bill is going to be directed at harmful online content. And of course, the big question is what's going to come under the definition of harmful online content. But so far, the government have said that they don't want to include a very precise definition. They want the content that's going to be covered by these legislation to be quite broad in scope. So instead, what they intend to do is have the bill contain descriptions of categories of material that are considered to be harmful online content. And it will be about then, I suppose, assessing whether the content will come in under one of those categories or not. And when we speak of, I suppose, expanding the scope of the type of content that is harmful, one of the main questions that has come up and issues, and it's one that's proposed in this bill, is that we shouldn't just be looking at material that is directed at a person. We should also be looking at material about a person. And I mentioned Section 10 and our existing offence of harassment. And that the wording of that is that a person must persistently watch, pester, beset, or communicate with another person. So the activity must be directed towards a person. Now, the harassment bill, the proposal in that is to slightly expand this position so that it includes where the person persistently communicates with a third person about a person. So it's slightly expanded in scope a bit. But the intention with this online safety bill is that it will include all material likely to have the effect of intimidating, threatening, humiliating, or persecuting a person to which it pertains. So it has a non-directional framing, and that will have a significant difference in what type of material can come under the scope of these offences. The reason for this, of course, was that it was felt that the non-directional framing just is a reality of online abuse. And of course it is, because you can have a multitude of content online that can be very upsetting to a particular person, but it mightn't necessarily be directed at them at all. So there are two of the main changes that may be coming down the pipeline in the next year or two. So when we speak of online realities, I suppose the anonymity of users, something that Gerard mentioned and I'll touch upon next, is the anonymity of users is a significant issue. So what can we do to deal with this? Well, Norwich Pharmacal Relief is a very useful tool in this instance. And on this slide, I've just taken a particular case to use as an example of explaining this concept. Some of you might be familiar with these headlines from August of this year. They involved Lisa McGowan, who's a social media influencer, well known for her account Lisa's Lust List. And what this case involved was Lisa McGowan claimed that her business was subject to harassing and defamatory statements online, but they were from anonymous users, and she wasn't in a position to identify the users and to allow her then to issue defamation proceedings against them. So what she did was she sought from the High Court and was granted an order directing Facebook to disclose the identifying information that it held in relation to the users in question. And that essentially is what a Norwich Pharmacal order is. So in the next slide, I've just looked at it briefly. It is an order directing the disclosure of documents or information to facilitate the identification of a wrongdoer. Now, when this case was reported on, many people considered it to be a successful application, a significant win against social media companies, Facebook in this instance, in that they were directed to disclose this identifying information that they wouldn't ordinarily have disclosed. But in actual fact, a Norwich Pharmacal application is generally not contentious. despite proceedings issuing and there being a plaintiff and a defendant, there isn't generally substantive allegations of liability against the defendant or substantive claims. And in fact, they're just there as an innocent intermediary because they have the information, the identifying information that the plaintiff needs. And it's because of this position, of this non-contentious position, that a lot of the time the defendant will be in a position to consent to the application, or more commonly take a neutral position. And what I mean by a neutral position here is that they don't consent to handing over the information and they don't object to it at the same time. So they let the court decide if it's appropriate for it to be ordered in the circumstances of that particular case. In the circumstances of the particular case. And that is, of course, very relevant here, because the type of information that we're disclosing when we're talking about identifying information is, for example, the name, perhaps a postal address, perhaps an email address or a phone number registered with a particular user. And this, of course, can come under personal information. And these defendant companies can't simply hand over this type of information to a third party for the asking. And that's why they must go through this legal process through the courts in order to hand it over. So why the name Norwich Pharmacal Relief? It is quite an unusual name. Well, it's because the Norwich Pharmacal application originates from a UK decision of Norwich Pharmacal and Customs and Excise. And just to explain a bit of background about this case and give you the context, this case involved patent infringement. There were counterfeit products which were being imported into the UK, and the owner of the patent and the licensees weren't in a position to identify these importers, but they wanted to issue patent infringement proceedings against them. And the only people that knew who the identities of the importers were the commissioners of Customs and Excise. But they refused to disclose the information on the grounds of confidentiality. So what the plaintiff did here was they issued proceedings, and one of the reliefs they sought was the disclosure of the identity of the importers. And this case went all the way to the House of Lords in the UK, and it was ultimately held that it was in the interest of justice for the information to be disclosed. The plaintiff should be in a position to issue infringement proceedings, and they needed that identifying information, and they were ordered to disclose it. And that is the origin of what we know as the Norwich Pharmacal Relief. So when did it come into Ireland? Well, as we see in the next slide, the first case which touched upon it was the Irish Supreme Court case in mega leasing. And this case just recognised the jurisdiction of the Irish courts to grant this type of order. It wasn't until the next case on the slide that this type of order was first granted, and that was in the case of EMI Records and Aircom. It was a High Court decision. It was in the context that Gerry has briefly mentioned of copyright infringement for the uploading and streaming of music illegally. And there were 17 subscribers that the plaintiff wanted the identifying details for so that they could issue proceedings against them. And here the High Court found that the right to privacy or confidentiality of identity must give way where there is a prima facie evidence of wrongdoing. So a Norwich Pharmacal order was granted in that instance. Now, as I mentioned, they're typically non-contentious, straightforward applications, but in the next two slides, I've just taken two examples of cases where they're perhaps atypical examples of how a Norwich Pharmacal application has run. So the first one is the Knowledge Academy Holdings and Google Ireland. This was an application for Norwich Pharmacal Relief against Google Ireland, and they took that neutral position that I mentioned in the earlier slide, neither consenting nor objecting to the application. And the court found that it was appropriate for the information to be disclosed, and they were disclosed to identify the identity of an AdWords account holder for the purposes of issuing trademark infringement proceedings and defamation proceedings in the UK. So the information was handed over to the plaintiff, but in this case, it was a bit unusual because the information relating to this account holder was actually turned out to be not genuine. So they had set up their account using a fake name and a fake address, and it was of no assistance to the plaintiff in going to issue proceedings in the UK. So they went back into court, and in these particular circumstances allowed it, because here you had an AdWords account holder. So of course they had to pay for the AdWord in question. So there was also payment details, which isn't necessarily always the case, but it was here. And the court granted an order requiring Google to disclose the payment information, which then allowed them to successfully identify the user in question. So the case on the next slide I'm going to look at is a case that Gerry has already looked at, and it's the Eimear decision, Eimear and Facebook Ireland. So in this case, there was, of course, the defamation aspect that Gerry has looked at and the Section 33 order. But another relief sought before the High Court was the disclosure of the identity of the user in question. And at the outset of these proceedings, Facebook took the general neutral position approach. But as the proceedings went on and further investigation was carried out into who the particular user was, it became apparent that the user in this case was a Ugandan activist known as TVO. And when they looked into it further, it became apparent that there was potentially a risk to TVO's life or to the bodily integrity of TVO from the Ugandan authorities if his or her information was disclosed. So this was brought to the attention of the court. And the court took into consideration two key pieces of evidence. The first was an affidavit from a human rights lawyer based in Uganda, who had been instructed by a man who was arrested on suspicion of being TVO. He was later released and found that he wasn't. But while he was arrested on suspicion of being TVO, he was subject to extreme abuse of his rights and also torture. And so there was evidence there to suggest that perhaps if TVO's identity was disclosed, he could be subject to the same type of abuse, or he or she, I should say. Another thing the court looked at was international human rights reports, and which the court held there was a consistency across them, because they all expressed a concern about the freedom of expression and assembly in Uganda, and that was also taken into account. So the court ultimately found that yes, there was a reasonable case to be made that there was a risk to the life or bodily integrity of TVO, and Mr. Justice Finchy wasn't satisfied to simply hand over the identifying information in this case. But at the same time, he acknowledged that there seemed to be an unfairness that the plaintiff, Eimear in this case, would not be able to take their defamation proceedings further, because of course, without the identity of the wrongdoer, they wouldn't be able to issue proceedings against them. So he took a nuanced approach, and what he did was he directed Facebook to contact the user and to let them know that if they didn't remove the content or the defamatory content, the subject of the proceedings, within 14 days, then he would go ahead and release the identifying information by way of a Norwich Pharmacal order. Now, in this case, the content was taken down and the information didn't have to be disclosed. And the decision itself was appealed to the Court of Appeal, and it was ultimately dismissed. So in the next slide, I've just looked at a few practical tips about surrounding a Norwich Pharmacal application, whether you're maybe in a position where you want to file an application or if you're in receipt of an application. And most importantly, the first one here is to identify the particular content at issue and to save the content, so by way of screenshot, but also to make sure that you keep a record of the URL. So of course, the nature of online content is that it can be deleted by the user at any time. So you don't want to be in a position where the content at issue is no longer available to you and you don't have a copy of it to show the court. But also, especially if you're dealing with social media companies or platforms, they can have millions, if not billions, of pieces of content on their platform. And sometimes a screenshot just isn't enough to identify content. So it's always best practice to take down or copy the URL, which is the Uniform Resource Locator. And it's essentially the address that's in the address bar when you're viewing the content. Also, it's important to identify the specific information that you require. So whose identifying information do you need? Is it the original poster of content? Is it a person who has commented on that original content? Is it a person who has shared it? And just to make sure that you have the details, or as much details as possible about that particular piece of content, including, as I said, the URL. Now, next, sometimes people forget this because a Norwich Pharmacal application, of course, is non-contentious. So it allows for there to be non-contentious engagement with the defendant in advance of the issuing of the application. And this can be really helpful because, of course, you can discuss with the defendant what type of information they hold, what type of information they'd be happy to take a neutral position in disclosing, and you might be able to agree the terms of an order with them in advance, which of course will save a lot of time and costs throughout the progress of the application itself. Costs when it comes to an Norwich Pharmacal application, well, the general position here is that a defendant is entitled to their reasonable costs of the application and disclosing the identifying information. And that is because a Norwich Pharmacal application is considered to be akin to third-party discovery application. So there's no allegations against the defendant. They're an innocent party, and so their reasonable costs should be covered. Now, in practice, we find that sometimes the defendant won't pursue the costs, particularly if the application is straightforward and terms have been agreed in advance and dealt with efficiently. So you might ask why, if a Norwich Pharmacal application seems so intrinsic to identifying and dealing with online content, why isn't it being considered in a statutory footing? Why isn't it there to date, and why isn't it now forming part of the new legislation that I mentioned? And this is a question that was put to the government in the context of the virtual workshop that I mentioned in the previous slide. And the government said that in the criminal context, An Garda Síochána have the power to require the disclosure of this information from online service providers. And in the civil context, it is open to a member of the public or whoever the aggrieved person is to seek this type of order from the court and to receive the information through that process. So there was an avenue to receive this particular type of information. And they felt that at this time it wasn't appropriate to put that type of power in statutory footing, and in particular to give that type of power to the Media Commissioner, to the Online Safety Commissioner. So it's expected that for the moment anyway, Norwich Pharmacal Relief will stay as an equitable remedy that is born out of case law. So that's the summary of Norwich Pharmacal Relief, and we're going to just look at now a few take-home points, and I'll hand you back over to Gerard to cover his section.
Thanks, Eimear. Yeah, simply from my perspective, I think what's clear is that since the e-commerce defences have come in, we've seen a huge increase in claims and different types of claims that are being made, and how the legislator is trying to deal with that. But particularly the important point is to what extent notification has been provided that's sufficient to put somebody on notice that they're under an obligation to do something about it. That works both ways, both if you're complaining to another provider that there's something defamatory about you or something that affects your company. You want to make sure you're notifying it quite precisely. As Eimear had mentioned, the use of URLs is really useful in helping it to be identified from the recipient side of things, so that you're putting the company on sufficient notice that there is illegal content there and they need to act sort of expeditiously on it.
Yeah, and so from my side then, the new legislation is great to just keep in mind, and I suppose watch as it goes through the practice, because it will have a significant impact on the type of content that's going to come under the legislation in the future. And also the introduction of the Commissioner will introduce a significant change into that area, and it is one of the first pieces of that type of legislation in Europe that is being considered. In terms of Norwich Pharmacal Relief, I suppose the take-home point is that it is a very straightforward application. It can be a very efficient tool to identify a wrongdoer, and that it is a non-contentious application, and it does give rise to a great opportunity for correspondence to pass between the plaintiff and the defendant in advance to make matters more streamlined and more straightforward.
Great. So I might just deal with some sort of questions that have come in on the Q&A function. There's actually a question here, Eimear, of what was the outcome in the Lisa List case?
Yeah, so as I mentioned, that case, the Norwich Pharmacal relief was granted a few months back, and as far as I'm aware, the substantive case, so the defamation proceedings against the users, hasn't yet been issued. So that's perhaps one to watch down the track.
Okay, there's a question here about juries in defamation cases. Why is this the case, and is it likely to change? Yeah, it's fairly archaic, I suppose, the concept of a jury trial. It's one of the only cases that still has it. Its history, I suppose, is around the sort of constitutional right to protect one's name, and that a jury of peers is best placed to sort of assess whether that reputation has been tarnished, etc. But it does seem a little, so archaic in the context of having, let's say, social media platforms equally joined to the case, where there are now obviously technical legal defenses that would be raised. There is sort of talk at times about abolishing it because it's considered to be quite costly, obviously, but also that the damages awards that are granted, I think we've all seen the headlines at times, particularly in newspapers, going down for huge sums of money, that they invariably appeal through the court process is something which I think the legislator, etc., is sort of conscious of, and equally the unpredictability of cases, I suppose. So we probably will see at some point a move away from that. Another question here is what type of information is generally disclosed in an Irish Pharmacal order? Eimear, if you want to deal with that.
Yeah, sure. So in terms of the standard type of Irish Pharmacal order that we see most commonly, particularly when you're dealing with internet service providers, it's generally, say, an account name, a name that is registered on creation of the account, an email address, a postal address if it's there, although some internet service providers won't require that as part of their signing up process. Typically, more recently, you'll have a phone number that's registered to it. And also there is IP addresses as well. So the IP address for the creation of the account, and maybe some recent IP addresses covering like login and logouts to the account. So that's typically the type of information that you find in the order.
Yeah, there's another question here about the end. If the Norwich Pharmacal is granted, is the user notified that their information has been disclosed? I suppose you did talk about Eimear there and the fact that there's this 14-day sort of period to take it down, or else something would happen. But we have seen, and maybe you talk about that a little bit, we have seen service providers wanting to tell their users that this is going to happen, I suppose.
Yeah, exactly. So there's no requirement. It's not part of the court order generally, and they're not required to notify the user as such. But as Gerard mentioned, we have found that in practice, they will generally be notified now at the time that their information is being handed over.
There's a question: can the plaintiff publish the user's identity when they receive it? And I'll answer that. I mean, the answer to that is no. The issue is that these details are simply being provided for the purposes of proceedings, and in fact, the case that Eimear talked about from Kelly J, the Aircom decision back in 2005, part of that order had an undertaking in it that the information wouldn't be used for anything other than the pursuit of the proceedings. And obviously, if the proceedings didn't happen, then nothing could happen with the information. So there are safeguards in place to prevent, let's say, publication of sorts. Another question is: how difficult is it to get an Irish Pharmacal order from Ireland if the service provider form is hosted in a different jurisdiction? Well, the answer is you won't get it from Ireland, in the sense that the application needs to be made to the company that has the information to give and where that is based. So, for instance, in the Knowledge Academy case that Eimear had mentioned that we were involved in, involving Google, there was an English case that was ultimately taken. So they went to Google in the UK, who didn't have the information, but Google Ireland did. So the application had to be made in Ireland for that purpose. So certainly, if there is a foreign service provider that has the information, you need to go to that sort of jurisdiction. I think there's the final question here, Eimear, unless anyone else has anything else. On social media harassment, until the Harassment and Harmful Communications Bill is enacted, what recourse does someone have if they're a victim of this type of harassment in Ireland? Presumably, and we have seen it, a lot of complaints come in from solicitors that their clients are being harassed online through social media and the like. But maybe just talk about what recourse there is at the moment pending this legislation.
Yeah, so at the moment, harassment is a criminal offence under Section 10 of the 1997 Act, as I mentioned. It's quite narrowly drafted at the moment, and is often not a very effective recourse depending on the type of content involved. But what is probably worth mentioning here is that many online service providers now have their own policies and their own reporting tools. And so in the first instance, we would always say that before moving to issuing proceedings or considering the legal avenue, it's always worth reporting the content, because it may fall foul of their own online policies if they have harassment and bullying policies on their platforms.
There's a question that's come in around online platforms that operate from the US and disclaim all liability for content. You talk to any avenues available for recourse against such platforms where they refuse to take down content asserted to be defamatory. Well, the US side of things, I suppose, has to be dealt with in the US, and what the sort of the law is around there. Certainly, if we take it from an EU perspective, if a company has hosted content and it's claimed in Ireland to be unlawful, disclaiming liability in T's and C's or anything like that, it isn't necessarily going to be a defence to it. The whole structure is whether there's been sufficient sort of notification, let's say, of the defamatory content and whether they've acted expeditiously within it. Having said that, if you look at the Eimear decision, for example, the defence of innocent publication provides a sort of the ability to suggest that there is no liability there. It's a difficult one because, on the one hand, these platforms don't want and aren't obliged to monitor anything, and they find themselves in quite a difficult situation by way of trying to establish whether something is right or wrong. Complaints obviously might come in all the time, but I think a sort of a disclaimer for liability certainly would go against the legislative framework and may be susceptible to sort of a challenge if it came up as a sort of a defence. The last question actually is just about the, actually one's come in, sorry. When you mention harassment, how are certain state employees protected from bullying harassment in their personal capacity, such as social workers? Eimear, do you want to have a go at that?
I'm just having a read. Yeah, so I suppose in their personal capacity, you have the same avenues as the general public in order to you can file a complaint and issue proceedings, and certainly we have seen some employers as well take some action on behalf of their employees where it is where there is persistent.
That's I suppose the difficulty at the law at the moment. It's around sort of persistence, isn't it, and sort of whether it's unlawful on that basis. We have seen in the context of complaints about any person, regardless of whether they're a state employee or the like, sometimes there are GDPR grounds raised if there are photographs used and the like, particularly if other family members may be present in those photos. So we have seen complaints come around that, and there to be sort of a legal basis to suggest that the content should come down. sorry, the last question here is simply about access to the recording of the webinar. And I suppose I'll use that as the opportunity to conclude. And yes, there will be an email circulated later today with a recording of the webinar. And there'll also be a survey there, which obviously ask about the webinar, but equally ask if there's any topics that you might want to be dealt with in a future webinar from MHC. And we'd obviously take that on board and try and facilitate that. So I'd like to thank you very much for attending this morning. We hope you got something from it. And if there are sort of any follow-up questions and the like, you'll see our contact details there on the last slide. Thank you very much.